Hi, welcome back. It's Andy Stautz at Stautz Law, and we're here for another quick informational chat, this time about trust terminology, aka the lingo. Oftentimes clients are intimidated by all the new terms, the new words they run into when they're talking to their estate planner or starting to read about estate planning and think about their options. So especially in the trust world, which is just a part, but an important part of what I do for my clients, it's worth knowing some of the terms so you can think about how you want your plan to work, and you can go into your planning meeting confident that you know what's going on. So just going back to basics, a trust is a legal relationship between three people. There is a settlor or a grantor, two names for the same thing, and that's the person who gives the property. And then there is the trustee. The trustee is the person who holds the property. And then there's the beneficiary. The beneficiary is the person who enjoys the property. So the clever idea of a trust is to separate the ownership, which is in the trustee's hand, and the use and enjoyment, which is in the beneficiary's hands. So your basic three players are the settlor or the grantor, sometimes even called a trustor, but that's very rare. The trustee, just called a trustee, there are no alternate terms there, and then the beneficiary. And the confusing part sometimes is that a grantor can also be a trustee and also a beneficiary, kind of, in some circumstances. And so that leads us to our next topic, which is, okay, what about all the different names for trusts? What's the difference between a revocable and an irrevocable trust? A grantor or a non-grantor trust? What about an asset protection trust? And the thing there to understand is those are just descriptive titles. Those are just different ways of explaining the type of trust you're talking about. Because the basic concept of separating legal and equitable ownership can be used in so many different ways. So if you're saying a trust is revocable or revocable, that just means that the grantor can decide to take it back and unwind it. Versus irrevocable can't be revoked. The trust can't be undone once it's been made. Same thing with a grantor trust for tax purposes is one where the grantor retains, is still the beneficiary in some way, versus a non-grantor trust. Same thing with a self-settled trust. As you might imagine, the self-settled means the settlor, the grantor, has put the property in trust for himself or herself. So self-settled. And so for many of these concepts, they can be colloquial. They're just descriptive terms, and sometimes it's kind of insider knowledge. Okay, what's a Medicaid asset protection trust? Do we call it a MAPT? Or then you get to sophisticated terms, SLATs and GRATs and, all these increasingly esoteric acronyms. Well, they're all just different ways to describe the type of trust that's being created, just a convenient technical shorthand. But the basic terms to remember: settlor or grantor, trustee, beneficiary. And that basic relationship works for all trust, no matter how complicated, because that's what makes the trust the trust. Hope you've enjoyed this overview. If you're ready to talk trust with me, I would love it. You can book an initial planning meeting online. You can give me a call, and I look forward to working with you with personalized advice for your situation and come up with the best plan that's going to work for you. Until then, bye now.